The Commission can also bring forward issues to the tribunal. So it's not just the individual that can file a human rights complaint. So another significant change is that the Commission itself can be an applicant, can bring forward an issue that has come to their attention and they think in the public interest it should be adjudicated upon by the tribunal. They can also seek to be a party to any process that's before the tribunal. And also I've referenced public interest intervener, sort of a legal distinction between being a party and being an intervener. Intervener can just make submissions, a party can call evidence. They can do both. So it depends on the nature of their interest and the issue at play. So very much still a very powerful entity in the province. And also, sorry, is there a question coming forward?
Sure.
Okay.
When you finish on that, I wanted to ask you a question 45.6 then again.
Yes, okay, we can, getting to that. Go ahead.
When you say that the Human Rights Commission can also make a complaint to the tribunal, is that like if they weren't happy with the decision that made, is that like an appeal process that you're describing in here?
Yes.
Or is there another area where if they wanted to appeal it that they would have another section in here to do that?
That's their ability to take a decision, and you can't really appeal anymore. It's really just a judicial review function, but they have an ability, and actually it's very broad because it's not just connected to their participation in the process, it's the outcome of that tribunal. And if that decision of the tribunal is seen as being contrary to their public interest considerations, then yes, they can essentially, it's like a stated case to the divisional court. So that's something a little bit new. But they also have the right to do that if they are a party as well. So that's just an add-on for them, essentially. The Legal Support Center, I identified that at the outset. It wasn't part of the first round of this bill, and it was really seen as, there was a little outcry by a number of the different lobby groups before the government, because there has to be seen as, there has to be some support or some assistance to applicants, because they're used to it now, and that's how it works. Under the new system, it's the Commission that does that for them. And this is similar actually to the workers' compensation scheme in Ontario, where you have the office of the employee advisor, where there are lawyers in there that actually act for employees. But for smaller employers, you have assistance through the province, but you don't have the same reciprocity under the Human Rights Code. So it really is a legal aid system to assist applicants through the process. And the terminology is supposed to soften the way of looking at human rights violations, getting away from complaints, and that's, I think, whether that assists people in bringing forward issues, I don't know. So why the change? I mean, we all know that the current system isn't working. It takes 4 to 5 years to get complaints through the system. But it's interesting when you look at the stats in terms of how many complaints actually get to the Commission in a year and how many of those complaints move forward to the tribunal. So think of, the gatekeeping function of the Commission actually bringing down the numbers of matters that get before the tribunal for adjudication. Now you're going to have all those complaints going right to the tribunal. So I guess the next question should be, is it going to work? And we're going to have to wait and see on that, because it seems that as the bill went through, they were adding in the same processes, but just in a different way. So we'll have to see. We talked a little bit about this already. And I think when it comes down to the new statutory civil action, the only time we're going to see that is if an officer is alleging action by the employer where it causes mental stress, really restricted ability, and they can add on a claim for damages on discrimination on top of that. I think that's going to be really rare. It's more the wrongful dismissal scenario, but that's big news in the province from a legal perspective, that you do have that ability to get damages that way. And that's just an indication of some of the funding issues that you're seeing with this new enforcement system. It's pretty significant. Let's get through that. So access to tribunal proceedings, although it's supposed to be more litigious, the tribunal can also direct mediation processes and essentially alternate dispute resolution processes. So the power to do that is taken from the commission and given to the tribunal. So from a practical perspective, there's not going to be a lot of changes. It just won't be as automatic and more subjective in terms of the tribunal reviewing the cases before it. Before we can knock out a complaint, it's that oral submission that creates a lengthier process. So it'll be interesting to see if the delay factor stays the same or gets better. Limitation periods, we talked about that. But the limitation period, how it runs, is really nothing new, but it's just codifying it. Running from the date of the incident, in the event of multiple incidents, the date of the last one. So that's really how courts have interpreted that, and tribunals interpreted it. It's been put into the code now. The restitution is an interesting issue on top of compensation, and we have to see how that gets further defined for loss of dignity and suffering. It's just broad, and the fact that you can have compensation plus restitution. It'll be interesting to see what the standard is in terms of proof of damages for restitution, because there has to be something you can demonstrate to get actual restitution, as opposed to a lump sum for compensation. So we're going to be watching that pretty closely to see how our risk increases on that end. Tribunal hearings and civil actions. Again, this is where somebody who commences a civil action can actually bring a matter to the tribunal to have them adjudicate the human rights component at a certain stage. Responses. And this is where the tribunal is really emphasizing on a going forward basis the obligation to bring forward documentation. That's where we're so well positioned in terms of our investigative action and the protocol that we have in place now. And we talked about the commission, and I think we have to really watch the inquiry function and see how that's further defined in the regulations. And it's similar to the new public complaints entity in the province for policing, where they have, it's interesting, it's similar language in terms of their warrantless authority to enter and all of the power that we'd like to have as a police entity to go in and investigate, complaints, public complaints. We can't do it, but they can. So a bit of an interesting dichotomy.
Very good.
So just to emphasize that the Human Rights Commission is still remaining very active in these issues and has a a number of avenues to insert themselves into the tribunal process. But I think, if you look at the media clippings around this, it's seen as a positive thing, right? And I think from a legal perspective, we're always concerned about having a third party push issues that we're trying to respond to. So when I give that sort of negative spin, it's in terms of our inability to maintain control of our response on a number of issues. So the transition period now, once we hit June 30th, we're looking at moving into this new system. We've got some transition processes with the complaints that have moved in and are already in the stream. I know that Doug Bowman and his team are quite well aware of how they're dealing with their current complaints on a going forward basis, and then we'll have to see how this new system hits us from a practical perspective. So there's a really short and sweet presentation on the changes. It's going to be interesting, but I think we're well positioned to deal with it.
Can I just ask one question then on your last comment then, where the police we won't have the right to go into an investigation, and then how will that get done?
Here's what we would love to have: an ability to get a warrant under the Provincial Offences Act for Police Services Act matters, and we're restricted from doing that. So we really have to rely on the cooperation of members of the public to provide us with information that we want. We see that a lot, in terms of cell phone records, other issues like that, where we really need to get the information to have a full and complete investigation. This the commission and the tribunal has that ability to get those documents and those records, which is great. I guess we'll eventually get access to that, but it's just interesting how there isn't the standard authority given across the board.
Any questions? Yes, Mr. Murray.
I have a couple of questions. Is